Hello everybody, welcome to iExamB's Legal Beat. This is Amrita, your law faculty here at iExamB. आज के इस वीडियो में मैं सीरीज कंटिन्यू करने वाली हूँ दैट आई हैव स्टार्टेड स्पेसिफिकली फॉर IBPS SO लॉ ऑफिसर एग्जामिनेशन. जो भी लोग प्रीलिम्स क्वालिफाई कर चुके हैं, मेंस के लिए प्रिपरेशन कर रहे हैं, देन डेफिनेटली उनके लिए वीडियो काफ़ी रेलिवेंट होने वाला है. मैंने बाकी के भी वीडियोस बनाए हैं जिसमें मैंने काफ़ी इंपॉर्टेंट क्वेश्चंस डिस्कस किए हैं फ्रॉम एग्जाम पॉइंट ऑफ व्यू. अगर आपने बाकी वीडियोस नहीं देखे हैं, जल्दी से जाके लीगल बी को सब्सक्राइब कर लीजिए. चेक आउट ऑल द वीडियोस. आज के वीडियो में हम लोग नेक्स्ट टॉपिक डिस्कस करने वाले हैं फ्रॉम एग्जाम पॉइंट ऑफ व्यू लॉ सिलेबस में से IBPS एग्जामिनेशन के लिए. मोस्ट इंपॉर्टेंट क्वेश्चंस फ्रॉम इंडियन कॉन्ट्रैक्ट एक्ट एंड स्पेसिफिक रिलीफ एक्ट इज व्हाट वी आर गोइंग टू कवर इन दिस वीडियो टुडे. First question, consent given under a contract shall be considered to be a valid one if there is coercion, valid consent, free consent, parties interested, either B or C. So consent contract में अगर दी जाती है तो ये valid कब होती है? The correct answer is very easy, free consent. Section 13 talks about consent, 14 about free consent. 15, 16, 17, 18 ये सारे ही सेक्शंस आपके लिए काफ़ी ज़्यादा इंपॉर्टेंट है. मैंने ये क्वेश्चन को यहाँ पे पिक इसलिए किया है ताकि आप ये सारे सेक्शंस पे एक बार नज़र मार लें एंड ये सारे सेक्शंस को इंपॉर्टेंट मार्क कर लें. डेफिनेटली ऑल दीज सेक्शंस आर वेरी इंपॉर्टेंट फॉर यू, सो बी thoroughly prepared with. The law of contract is not related to which of the following maxims? Quid pro quo, consensus ad idem, essentio mentio, ex nihilo pacto, action non orator, actus non facitum nisi mensat rea. बहुत ही सिंपल है ये. नॉट रिलेटेड टू पूछा है, डोंट फॉरगेट दैट. एक्टस नॉन फैसिट्रियम निसी मेंसेट रिया इज रिलेटिंग टू द क्रिमिनल लॉ एंड ये मैक्सिम यहाँ पे एप्लीकेबल नहीं होता है. इट इज नॉट रिलेटिंग टू कॉन्ट्रैक्ट्स, इट इज रिलेटिंग टू द गिल्टी एक्ट एंड गिल्टी स्टेट ऑफ माइंड. बोथ शुड गो टुगेदर. विच ऑफ द फॉलोइंग सिग्निफाइज अ प्रॉमिस? Offer plus acceptance, proposal plus acceptance, promise plus consideration, both A and B, either of the above. So इन सब में से प्रॉमिस क्या सिग्निफाई करता है, कौन सा फॉर्मूला प्रॉमिस के लिए फिट बैठता है? काफी सिंपल क्वेश्चन है ये. बोथ A and B talk about promise. Section 2B talks about a proposal when accepted becomes a promise. Both options are correct as offer or proposal both mean one and the same thing. For a contract to be valid one, it is required to be by the free consent of parties, to be between the parties who are competent to contract, not to be expressly declared to be void, both A and B, all of the above. So इनमें से कौन सा ऑप्शन सबसे करेक्ट है? For a contract to be valid, what is required? Correct answer is both A and B. The correct answer is all of the above. All of the above. Section 10 talks about what agreements are contracts. All agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration with a lawful object and are not hereby expressly declared to be void. So ये सारे conditions अगर fulfill होते हैं, then a contract to be valid, it is required that all these conditions are fulfilled. So the correct answer is all of the above. It should be by free consent of parties. It should be between the parties who are competent to contract and not be expressly declared to be void. और ये इसके लिए section 10 काफी important है. Agreements, the meaning of which is not certain or capable of being made certain, are void, valid, illegal, voidable, none of the above. So in agreements जिनका meaning certain न हो, they are known as void agreements. Section 29 के हिसाब से ये directly यहाँ से pick किया हुआ है. Agreements the meaning of which is not certain or capable of being certain are void in itself. A counter offer leads to invalid offer, invitation to offer, continuous offer, and acceptance of the offer, rejection of the original offer. So counter offer leads to what? What is the consequence of that basically? Correct option is rejection of the original offer. Person to whom offer is made instead accepting the terms of the offer desires modification of the same. A offers B a car for 5 lakh rupees. B agrees to buy for 3 lakh rupees. This amounts to a counter offer and it would mean a rejection of the original offer. Logically एकदम फिट बैठ रहा है, एग्जाम्पल से समझने में काफी easy हो जाता है. Later on, if B agrees to buy for 5 lakh rupees, A may also refuse that. So this is what is counter offer concept. Which of the undermentioned is not an exception to doctrine of privity of contract? Time barred debt, assignment of contract, contract through an agent, covenant running with land, acknowledgement और estoppel. So इसमें से क्या है जो कि doctrine of privity of contract का exception नहीं है? Remember that doctrine of privity of contract is an important concept and उसका क्या exception नहीं है ये automatically आपको पता होगा अगर आपको basic doctrine पता है तो. Correct answer over here is time barred debt. Section 25 talks about agreement without consideration is void unless it is in writing and registered or is a promise to compensate for something done or is a promise to pay a debt barred by limitation law. On the other hand, what doctrine of privity says, it is a common law principle, which implies that only parties to a contract are allowed to sue each other to enforce their rights and liabilities. No stranger is allowed to confer obligations upon any person who is not a party to a contract, even though contract has been entered into for his benefit. So ये हो गया यहाँ पे क्लियर डॉक्ट्रिन ऑफ प्रिविटी ऑफ कॉन्ट्रैक्ट इटसेल्फ एंड टाइम बार डेब्ट के बारे में भी हमने रेलेवेंट प्रोविजन देख लिया है. आप लोगों को अगर ये पास लग रहा है तो आप लोग वीडियो को पॉज करके वापस से पढ़ सकते हैं सेक्शन को या पीपीटी को सिंपली डाउनलोड कर लीजिए. आपके पास ये कंटेंट हमेशा रहेगा एंड इट विल हेल्प यू आउट. Preventive relief is granted dash the court by injunction, temporary or perpetual, at the discretion of, at the supervision of, as mandatory decision based on facts of the case. No such power is vested with the courts. So यहाँ पे preventive relief के power के बारे में बात हो रही है. It is granted in discretion or in supervision or is mandatory power या facts पे decide होता है या ऐसा कोई power courts के पास होता ही नहीं है. Interesting question है ये. The correct answer is at the discretion of the court and answer भी काफी simple है. अगर हम common logic apply करें तो हम इसे answer कर सकते हैं. This has been directly picked from section 36 preventive relief how granted. Which section of Contract Act defines void agreement? 2F, 2G, 2I, J, K. Correct answer is G. I would suggest all of you to at least try to remember these basics क्योंकि ये काफ़ी इंपॉर्टेंट कंसेप्ट है. कंसेप्ट के साथ अगर आप सेक्शन भी याद रखते हैं एटलीस्ट इंपॉर्टेंट वंस का तो ये आपके लिए अच्छा होगा. सो ट्राई टू रिमेंबर दैट मच. बेयर मिनिमम सेक्शंस वी कैन रिमेंबर. ओके. Consensus ad idem means mutual agreement, meeting of the minds to agree upon the same thing in the same sense, all of the above, both A and C. Now always remember at such time you may find that this option is also correct, this option is also correct, this option is also correct. ऐसा हो सकता है. I think आपके माइंड में ये ऑप्शंस देखकर आ रहा होगा. Correct answer is all of the above. Section 13 talks about consent. Two or more persons are said to consent when they agree upon the same thing in the same sense. It signifies that there exists a mutual agreement between all the parties to a contract. ये सब का मीनिंग एक्चुअली एक ही है. सो ऑल ऑफ द अबव यहाँ पे करेक्ट हो जाता है. A person who finds goods belonging to another and takes them into his custody is subjected to same responsibility as a bailee, same responsibility as a bailer, same responsibility as an agent, same responsibility as the owner. No responsibility is vested upon him. So a person who finds goods belonging to another and takes them into his custody, he is subjected to what? What kind of responsibility basically he is having? यहाँ पे पूछा गया है. Simple है. Remember, he is having responsibility as a bailee, as if the goods are bailed to him. Finder of goods का concept है ना वो यहाँ पे cover किया है. Section 71 and ये काफी important है. Go through it. When can an exemplary damage be awarded? Breach of contract to marry, breach of any business contract, wrongful dishonor of check by a banker, all of the above, both A and B. So exemplary damage भी एक important concept है. ये torts में भी हम पढ़ते हैं. यहाँ पे भी आप पढ़ सकते हैं contract में. Correct answer is E, both A and B. Intend to give punishment to the defendant and not intended to compensate for the loss suffered due to breach. This is awarded only in 2 cases. Specifically उन्होंने दिया है breach of contract to marry, dishonor of check by a banker. So यहाँ पे हमारे लिए काफ़ी स्पेसिफिक आंसर उन्होंने यहाँ पे दिया हुआ है. Wrongfully when there is a dishonor of check by a banker when sufficient funds exist at the credit of the customer. It is punitive in nature. Specific performance of contract may be obtained by any party thereto representative in interest or the principal of any party thereto. Contract is a settlement on marriage or a compromise of doubtful rights between members of the same family. Any person beneficially entitled thereunder. All of the above, both A and B. So specific performance of contract हम कैसे obtain कर सकते हैं? All of the above is the correct option over here. Section 15 talks about it. Who may obtain specific performance? काफ़ी डिटेल में सेक्शन 15 में ये प्रोवाइड किया गया है एंड आपको यहाँ पे मिलेगा ये सारे ऑप्शंस यहाँ पे कवर्ड है अंडर सेक्शन 15. This is the entire section. What are the remedies available to an aggrieved person in case of breach of a contract? Damages, recession, specific performance, all of the above, both A and B. What are the remedies that are available to an aggrieved person in case of breach of a contract? All of the above is the correct answer. Damages, monetary compensation देता है, recession, unmaking of contract and specific performance. ये सारे remedies available है. काफी simple question है. Grant of a mandatory injunction is regulated by Section 38 of Specific Relief Act, 39, 40, 41, none of the above. ये भी सेक्शन बेस्ड मैंने एक लिया है यहाँ पे ताकि आप अलर्ट रहे कि एटलीस्ट जो बहुत लैंडमार्क कॉन्सेप्ट है उसके सेक्शंस हम लोग याद रख लें. मैंडेटरी इंजंक्शन एंड टीआई सीपीसी ये काफ़ी इंपॉर्टेंट है, ये लैंडमार्क है, ये हमें याद होना ही चाहिए. सो answer is B. Mandatory injunctions are governed by Section 39 of the Specific Relief Act. Principle of quod emet means some future probable injury to the rights or interests of a person, some past injury to the rights or interests of a person, some past injury to the rights or interests of a person required, some small injury capable of being estimated in money, none of the above. So quod emet principle का actual meaning क्या है? A. Some future probable injury to the rights or interests of a person. यहाँ पे correct option होगा. Because he fears उसका actual meaning है. अगर हम literally देखें तो quod emet Latin means for because he fears. This is an injunction to restrain wrongful acts which are threatened or imminent but have not yet commenced. So ये future rights के बारे में बात करता है, not yet commenced. So इसके लिए accordingly some future probable injury to the rights or interests of a person, ये वाला option correct हो जाता है. Question of title is relevant under section 6 under the specific is not a provision under Specific Relief Act, partly relevant under section 6, irrelevant under section 6, none of the above. So title के बारे में क्या Specific Relief Act में कई बात की गई है, आपका सिविल लॉ का नॉलेज और बेसिक कंसेप्चुअल क्लैरिटी यहीं समझ में आ जाता है. Do we have anything related to question of title over here? Section 6. Correct answer is D. If any person is dispossessed without his consent of immovable property otherwise than in due course of law, he or any person through whom he has been or is in possession or any person claiming through him may by suit recover possession thereof, notwithstanding any other title that may be set up in such a suit. So ये irrelevant है यहाँ पे. Dispossession की बात हो रही है. So ये हमारा conceptual clarity होना चाहिए. Suit for possession under section 5 of Specific Relief Act can be filed within 30 years, 6 months, 3 years, none of the above, 12 years. ये भी काफ़ी important है. लैंडमार्क years का टाइम लिमिट ये बहुत बार पूछा जाता है. So ये आपको याद होना चाहिए. Correct answer over here is E, that is 12 years. Section 5 के हिसाब से. 65 अगर आप देखेंगे लिमिटेशन एक्ट का तो आपको इसका आंसर भी मिल जाएगा. Suit for possession of an immovable property under section 6 of Specific Relief Act can be filed within 1 year of dispossession, 6 months of dispossession, 3 years of dispossession, 12 years of dispossession, none of the above. So section 6 के हिसाब से suit for possession of an immovable property जो है वो कितने दिन में फाइल कर सकते हैं? Correct answer is 6 months. इसका स्पेसिफिक सेक्शन है सेक्शन 6. 5 and 6 यहाँ पे आपके लिए काफ़ी इंपॉर्टेंट है स्पेसिफिक रिलीफ एक्ट से. ये मैं आपको सजेस्ट करूंगी आप बहुत अच्छे से पढ़ें. So the last question for today's video: who may obtain specific performance of a contract? Any party, representative in interest or principal, where contract is settlement of marriage or a compromise of doubtful rights. In that case, any person who is benefiting out of it, where the contract has been entered into tenant for life, the remainder man, all of the above. So क्या ये सारे लोग कर सकते हैं? तो करेक्ट आंसर ऑल ऑफ द अबव ही है यहाँ पे, क्योंकि सेक्शन 15 टॉक्स अबाउट हु मे ऑब्टेन स्पेसिफिक परफॉर्मेंस और ये सारे ही ऑप्शन उसमें से पिक किए गए हैं. A B C D अगर आप देखेंगे तो ये सारे ऑप्शंस वहीं से लिए गए हैं. इतना बड़ा सेक्शन है, आप इसको अच्छे से पढ़े, सेक्शन इंपॉर्टेंट है इसलिए मैंने यहाँ पे पूरा कॉपी पेस्ट किया है इसको यहाँ पे, ताकि आप इसको अच्छे से पढ़े एंड इट इज़ इम्पॉर्टेंट एज वेल. So thank you everybody. Here I would like to stop my video. You can rewind the video and you can go through all the provisions, या simply PPT को download कर लीजिए. कोई भी queries हो, do reach out to us. We are there to help you out. Prepare 50% faster with us at iExamB.